All right, here we go. Okay. All right, just going to go through a quick policy statement. First thing I want to talk about is some of the landowners we've got, or some of the resources we have for landowners. This is the oil and gas website that's specially designed and is only oil and gas fracking information for the public. Landowner info for oil and gas leasing is one of the handouts that I have out there for you. It talks about the oil and gas lease, what the language in the lease means, and some alternative language that people in other parts of the country have used to negotiate changes in the lease. State of Michigan oil and gas lease is another handout I have out there for you. State of Michigan has more minerals under lease than anybody in the state. Every oil and gas company that deals with the state of Michigan uses their lease. So it's a very good comparison with the lease you're offered from a landman. You can compare that lease with what the state of Michigan is using. Oil and gas resources for landowners is another handout I've got out here for you. It is a list of attorneys that have told us one of their specialties is oil and gas leasing. So if you want to consult with a legal expert on your lease, there's a list for you. And along with oil and gas development, any kind of development, there can be right-of-way opportunities, pipelines, roads, that kind of thing. So we've got information on the rules of the game on rights-of-ways, because you need to know those rules or you can leave a lot of money on the table if you're a landowner. And then a new publication on our website is by an oil and gas attorney in Colorado that's very complete and is another really good resource to learn about leasing. There's a lease addendum on the website. It's an addendum that's actually been used on a lease in another state. It'll give you an idea of what language has been changed in a lease by another landowner. And then I have an oil and gas newsletter that I publish quarterly that's free. And if you want to subscribe to that by email, you can email me at that address. And then MSU Extension has MSU News, and I try to publish some articles on oil and gas in that format also. Okay, this is a picture of a well in Pennsylvania that's being hydraulically fractured. And what my point here is that, like has been brought up before, these are bigger wells, bigger pads, more potential impact. And it all begins with you, the landowner. This is where it all starts. Now, my background is when I was with private industry, I managed farms and ranches for absentee landowners. So I negotiated with oil and gas companies in Colorado. From that experience and working with landowners in Michigan, we put on these meetings so that you can learn from other landowner experiences. You can learn your options when considering leasing, so that you can make informed, confident decisions when you decide to lease or not lease. And I do want to say that the oil and gas industry is doing an amazing job of producing our oil and gas right now. I mean, the technology that they're using is working. In fact, right now, the U.S. is awash in natural gas. The inventories that are in storage are the highest they've been ever for this time of year. Natural gas prices peaked at $13 per million BTUs in 2008, and now they're down to $2.01, so they've gone down 646%. Oil has gone down about 30%. Oil is where the money's being made right now. Companies are not making money on natural gas, so where they're going to new leasing, they're looking for oil. But also, because natural gas prices are low, there's a possibility that the companies are going to do the minimum required to keep these leases in effect, because there is no profit in natural gas at this point. Okay, this is a map of what is called the unconventional shale plays. Before horizontal drilling and hydraulic fracturing really became effective, every one of these areas was thought to not be feasible to produce oil and gas because they were shales. The Barnett underlies the Dallas-Fort Worth Metroplex. I'm going to talk about the Marcellus Shale. It's been estimated that in total energy, the Marcellus Shale has as much energy as Saudi Arabia. This has all happened from starting to develop these shales. The Bakken Shale is in North Dakota. It's oil and oil liquids. Brand new discovery, producing 500,000 barrels a day right now in new oil. So the technology is working. And when we're talking about the royalty for landowners, we're not talking about pocket change. Let's take a look at a situation here. Let's say you own 40 acres. One well is drilled that produces 25 barrels a day, produces 200 days at $90 a barrel. That well is going to gross $450,000 per year. Now, if you get a 1/8 royalty, that's $1,406 per acre per year. If your royalty is based on gross income versus net income, that's what potentially you can receive. And landowners, for example, the state of Michigan receives a 1/6 royalty. The standard lease you're offered is a 1/8, and private landowners have negotiated from anywhere from 1/8 to 25% royalties in the state of Michigan. There's a 25% royalty I've verified in Jackson County that occurred last year. So there is room to change these leases. And the important thing here is long-term, do you make your money on that $100 an acre bonus payment you get one time? Or do you make your money and protect your land long-term by what's in the lease? It's what is in the lease that counts. Just by changing the royalty to 1/6, there's a $400 per acre change in income the first year. That's a lot different than comparing a $50 an acre bonus with a $100 per acre bonus. So, mineral rights many times are treated as second-class citizens. People are offered a lease, they're offered a bonus, and a lot of people say, where do I sign to get this check? They do not check out the lease, and that's where the real impacts with the goals for your property can come. But if you do not support drilling on your property, do not sign an oil and gas lease. It's not fair to the company to sign a lease, want that bonus payment, and then fight everything they try to do. You're selling them the right, basically, to harvest your minerals. If you don't want drilling to occur on your property or development, other than a non-development lease, which I'm going to talk about here in a minute, don't sign the oil and gas lease. A lot of people have signed in the past, got the bonus, the oil company never came around, and everything was fine. They got lucky. They got the bonus, no drilling. Don't expect that, because if they do come around and you paid no attention to the lease, you got to live by that lease, whether it's good or bad, and you get one opportunity to do the leasing right, and that's when you're getting all these phone calls from the landman. So oil and gas lease is the marketing plan for your mineral rights. If you're a corn farmer, you have a marketing plan. If you're a timber producer, you have a marketing plan. The lease is the marketing plan for your mineral rights, and these leases can last for generations. It's not a short-term thing, particularly with the way some of these leases are written. So be aware, you're looking at very long-term agreements. And it can be a win-win situation, but the lease is written by the company for the company. That's the way it is in business. When you are writing the agreement, you're going to write the agreement to benefit you. So you as the landowner have to look out for yourself. You have to determine what is in that lease document that you like or don't like, And then you can decide if you want to make changes or not sign that lease. They're not going to tell you what is bad in the agreement. The landman is real good at telling you what he wants to tell you to get you to sign the lease. And it's up to you to know what is good and bad in that agreement, and that's why you're here tonight, to get that information. So it can be a win-win. And it's very hard for a landowner because you're offered this bonus over here, this check. And over here is the lease. And this is a document, when you try to read it, you don't understand it anyway. You know, so it's really hard to juggle these, but I can't tell you how many phone calls I've had from people that have signed the standard lease, then they started learning what was in it, and then they call me and ask me, how do I get out of it? Well, you don't get out of it once you sign it. You have to know what's going on before you sign the lease. Okay, let's talk about the royalty, because the royalty is one of the most important parts of the lease, because that's what determines what income you're going to receive. Well, the federal government gets an eighth, the state of Michigan gets a sixth, and private landowners have gotten anywhere from 1/8 to 25%, as I mentioned. Okay, what landowners have learned is they want that royalty paid based on gross proceeds, including all substances contained in the gas and oil, produced from the leased premises in marketable condition at no cost to lessor. You want a cost-free royalty. If it's not cost-free, it's having post-production costs deducted, which I'm going to talk about here a little bit later. So that's your goal, a cost-free royalty. Okay, I mentioned the Marcellus Shale in Pennsylvania. Okay, early on, before the companies knew how to manage that, the Marcellus, how to develop it, frack it, they weren't sure what they had, so they were offering 1/8 royalties. Okay, in a letter to one of the big companies' shareholders just recently, now they are budgeting 20% royalties based on the gross income. You know, early on, they didn't know what they had. The people that waited and didn't just sign immediately, they're getting a 20% royalty based on gross income. Sometimes they'll both agree to a post-production cost if it enhances market value for both. Bonuses of up to $6,000 per acre are being offered. I had a guy from Texas call me the other day. The Eagle Ford Shale in southwest Kansas, right now they're offering $25,000 per acre bonuses and 20% royalties. So things can change really quickly in this business. Many small landowners, I mentioned the Dallas-Fort Worth area, they are literally leasing subdivisions. I've seen leases for 1/10 of an acre. So you know, if you're a small landowner, you can still participate. If the minerals are there, they've got to pay you for those minerals if you're involved with a well. And then most of these wells are around 9,000 feet deep in the Marcellus. And the well here in Michigan that started the frenzy in the summer of 2010 was 9,000 feet deep. Okay, the trick for a landowner is you have to become a price maker instead of a price taker. You have to learn to become a negotiator because you're dealing with the landman. And like any good employee, he's out there to make his boss happy. And how he makes his boss happy is to get you to sign a lease. And he's experienced, and he knows how to push your buttons. He knows how to put the pressure on, and you've got to learn to deal with that. And anything the landman tells you, you need to check out his statements. I mean, that's just the way it is. Check out my statements. Check out every speaker's statements that were here tonight, because there is so much information out there. You've got to sort all this out and determine what fits the goals for your property. So if he tells you your neighbor is already leased, go ask your neighbor. I've had people call me and they say, well, the landman said everybody around me is leased but me. I'm the holdout. And I said, well, have you checked with your neighbors? Well, no. So he calls the neighbors. Well, they haven't leased. I was wrong. And just because they may have leased, that does not mean they signed the standard lease. Particularly if you work with your neighbors or have large acreage, you have negotiating clout. And you may have negotiated a change in the lease that the landman, or that neighbor may have negotiated a change in the lease that landman forgot to tell you about. So just because you hear they signed, that doesn't mean they necessarily signed the lease they're offering you. So everything is negotiable, but you have to be firm, and I can't emphasize this enough. In fact, you have to be tough as nails, and there are days you have to get this way. That's just the way it is. If you've been through it, you know what I mean. There can be a lot of pressure put on you to sign the lease. Sometimes you have to get grumpy, and sometimes you feel like you're the biggest jerk in the world. But if you're not ready to sign, don't feel the pressure to sign. I've had landowners tell me, just to get rid of the landman, I went ahead and signed the lease. And now I regret it. That is not the reason to sign a lease, is to get rid of the pressure. You may not arrive at an agreement. That's okay. It's a choice to lease. You've got the goals for your property, and if that agreement doesn't fit your needs, don't sign it. You are in control. The landowner is in control. Good leases take time and last a long time. The leases I was involved with in Colorado, we negotiated in 1985. When that farm was sold, and we sold the mineral rights, the new owner inherited that lease because there is oil and gas production going on. Those leases are still in effect. So same exact lease. That landowner is using the same lease we negotiated. Because once that lease is signed and it's held by production or held by any of the terms in the lease, that's going to continue for as long as those terms exist. That's why I say these are very long-term agreements. Now, one thing you can do is you can learn some negotiating tools, and one effective tool is a scapegoat. And if you've heard my presentations, you know what's coming next. But I use my wife as my scapegoat. She's always telling, these women are always telling us men we don't listen. Why don't you listen? If you'd have listened, you'd have heard what I said. Well, so we agreed that when I was talking to the landman, I would say, my wife will not let me sign that lease. We went over it last night, and she will not let me sign it. A great way to take the pressure off yourself. You can use your attorney. It's the oil and gas company uses the same tool. Nothing wrong with it. It takes the pressure off of you. When you don't have that pressure on your shoulders and you can blame somebody else for being the bad guy, it makes you a much better negotiator. And of course, because these are binding contracts, that's why we have that list of attorneys and consultants that can help you, if nothing else, at least totally understand what you're signing. And they can help you negotiate, too, if you want to hire them. One thing that is becoming very common, and it started out in the western United States with wind farms, is working with your neighbors. Actually, this is better for you, and it's better for the oil and gas company, because the more acreage you can block up, the more negotiating clout you've got, and it's the less landowners that the oil and gas company has to work with. So don't be afraid to work with your neighbors, talk with your neighbors. You can go, from very informal to even forming an LLC, and all the group agrees to abide by the lease terms that your committee negotiates, for example. So nothing wrong with working with your neighbors. Now, this is an example of some of the hydraulic fracturing and horizontal drilling. And if you're a landowner, some of the good things about these horizontal wells is it is friendly to surface owners, because you can group up wells in one place and you don't have a lot of wells scattered all over. When I was in eastern Colorado, you could drill a well every 25 acres. So if you're trying to row crop or timber, that can be a big impact. Well, this is a picture taken within the city limits of Greeley, Colorado. And I'm standing on a highway overpass. Each one of these is an oil and gas well. There's 33 wells on this pad, and this is 1/2 of the site. You can see there's a railroad. I'm on a highway. There's industrial facilities. How are they going to harvest the minerals under that building? Well, they use horizontal drilling or directional drilling. They put the well here. They run underground and harvest the minerals under there with a non-development lease. And I'll talk to you about a non-development lease here in a minute. So grouping the wells together is less surface impact for a landowner. And if you use your land to make a living, that is an important thing. Now, what are there? There's several types of oil and gas leases. This first one is the one that used to be offered many years ago, and that's where you were paid so many dollars an acre during that primary term. So if you have a 5-year lease, until they drilled a well and paid you a royalty, they paid you like $5 an acre or whatever. Well, they're not offering that anymore. What they're offering now is the paid-up lease. And it says paid up usually right on the front. What that means is that all the cash that you're going to get until you start receiving a royalty is in that bonus payment. And that bonus payment is that check they offer you, like $50 an acre or $200 an acre. That's the bonus payment. So the only cash you get is from that. Now, I mentioned a non-development lease, no surface use lease. This is really effective for small acreage producers, small acreage owners. There's no surface disturbance or structures. That's where the horizontal drilling is good. They can just go under your ground, put nothing on the surface, harvest your minerals with the horizontal well. So no well site, no roads, no pipelines, no tanks. It's all underground. And then with the no surface use, you can also make sure that it says there's no pipelines without owner permission. So no impacts at all, other than they want to go underground, harvest your minerals, pay you your royalty. Now, with compulsory pooling was mentioned a little while ago, and I want to talk about compulsory pooling because I've had landowners tell me, you know, one of the negotiating tactics the landman uses is, well, if you don't sign the lease, I'm just going to take you to the state and compulsory pool you anyway. So, you know, you don't really have any option. Compulsory pooling is a very good option for some people, particularly small acreage owners. The state of Michigan uses it in environmentally sensitive areas. It only deals with one well. So if your neighbor has a lease and you've got some land unleased and the state, well, the oil and gas company has got to show the supervisor of wells that all the land that a well is going to harvest is either under a lease or a compulsory pooling arrangement. So you're not going to ruin it for your neighbor if you don't lease, because what will happen is the oil and gas company will do everything they can to get you to lease, and if you can't, they can take you to a compulsory pooling hearing. And to avoid not letting your neighbor get the royalties, the supervisor of wells will say, okay, we're going to compulsory pool. Let's say they need 40 acres of your land, 40 acres of the neighbors. They're going to pool those together to make an 80-acre site for that 80-acre well. So it doesn't take all of your land. It only takes what is needed for that drilling permit for that one well. You receive a 1/8 royalty that is based on the gross income, cost-free. The judge orders that that's how you're going to get paid your royalty, because post-production costs are illegal in the state of Michigan unless you agree to it in the lease. And we're going to talk about that a little bit more. So it's cost-free. It's a non-development lease, so there's no facilities, no well. You don't sign a lease. You don't have to worry about negotiating the lease. Doesn't ruin it for your neighbor. Everybody can get a well. So the compulsory pooling threat is not a reason to sign a lease if you don't like the lease. We had a meeting down in Washtenaw County earlier this spring, and a landowner got up that's up in the Traverse City area. He has been compulsory pooled, and he thinks it's great, just because of these reasons. You know, he didn't have to deal with the hassle of the leasing. So the oil and gas lease is basically selling somebody the right to harvest your mineral rights. The first clause in that lease is called the granting clause. And if it's an oil and gas lease, you want it to say the sole and only purpose is drilling and operating for oil and gas. Because a lot of these standard leases may include potassium, helium, any other minerals. Well, if it's an oil and gas lease, why is there any other minerals in the granting clause? That means if they find any other minerals they want to harvest, they're going to pay you the royalty you signed on for, whether or not that is the market royalty or not. So, watch for that. Communication towers, power stations, or storing gas is part of that granting clause. Granting means you're granting it for free. The state of Michigan is one of the most prolific states used for storage of natural gas in the United States. Lots of storage of gas occurs. Well, if you give it away in the oil and gas lease, you're never going to get paid for it. If you know to have this deleted, if they ever want to store your gas under your property, you can get paid separately for that. Storing gas is not producing gas. It's totally different. And any other land adjacent there too, or appurtenant, is almost always in the standard lease. It obligates your other lands. I was just talking to somebody the other day. He's got 2 tracts. One he feels is very environmentally sensitive. He doesn't want in a lease. Well, if this is called the Mother Hubbard Clause. If the Mother Hubbard Clause is in that lease, at a later date, the oil and gas company can add that other land into the lease if they want to, because you gave them permission to add appurtenant lands at a later date. In that granting clause, it talks about putting in pipeline, roads, and convenient and useful easements. Now, who's it going to be convenient for? If you grant convenient, it's going to be convenient for them. And that's why I say, don't sign the lease if you don't want development, because you're going to have roads, you may have a well site, so you need to expect these, but in the lease you can negotiate where those are going to go, any non-development areas you do not want any development, and a lot of other things we're going to talk about. If you just carte blanche say the pipelines, any pipeline they put in is put in for free. If a pipeline crosses your property that has oil and gas from someone else, you are owed a right-of-way payment. And these are paid by the foot. So if you give it away in the granting clause, you're not ever going to get the opportunity to sell a right-of-way. Warranty of title is always in the standard lease. Landowners have learned they do not like that. What that says is that as long as records have been kept, every deed that's been recorded in the chain of title was done correctly. And if they find an error, you are warranting you will fix it at your cost. They've got very good title company people working to check the title anyway, so landowners have learned they do not want the warranty of title language in the lease. Now, the primary term is the initial term. For example, you may have a 5-year lease with a 5-year extension. Okay, the 5 years it talks about is the primary term. That is the time period that it gives the oil company to start drilling and producing you a royalty. Landowners want the primary term to be as short as possible because they want them to, you're signing a lease because you want royalties. So they want to give them lots of incentive to get out there and get to work and not give them a lot of years to wait to do that work. And a lot of the standard leases have automatic extensions of 5 years. You know, I mentioned at the very beginning we're awash in natural gas. What I fear might happen is the very minimum that these leases require, that's what the company is going to do to maintain the lease, because it's all about controlling land. They don't want to negotiate a lease with you again. They don't want their competition to get that land. So they're going to use every bit of fine print in that lease to keep that lease once they get that land. Landowners have learned they can just do a 3-year lease, period, 5-year lease, period. You don't have to accept a lease with automatic extensions. The standard lease talks about pooling land, and I gave you an example of that a minute ago. Pooling is a good thing, but it can be taken to extremes. An example, I'll give that example again. If you've got 40 acres, your neighbor's got 40 acres, the company needs 80 acres for a drilling permit, because that 80 acres is what they want to harvest. They will pool those lands together for the drilling permit. Well, in that standard lease, they can do a lot more pooling than just what is needed for the drilling permit. And let's say if you allow pooling of 1,280 acres, they can drill one well in that pool, and that well may not be on your land, and that's going to hold all those 1,280 acres for possibly perpetuity, because you allowed it in the lease. You allowed unlimited pooling. So that's something that needs to be watched for. A real important couple of words here. The standard lease always says it will remain in force until production permanently ceases. Okay, what landowners have learned is to change that lease to when it stops producing and paying quantities, the lease stops. I'm working with a landowner up north that's got 6 wells on his property. He hasn't received a royalty in 2 years, but he's got these words in there, permanently ceased. The company says that the wells are producing just enough gas to maintain the wells. So they're still producing because it hasn't permanently ceased, so he's stuck in that lease because what they're doing is following the lease. But if they stop paying you, if he'd have had, when they stop paying me, the lease will terminate, his lease would have terminated. So one important thing that the people in the know use is called a pew clause. And what that says is, if land that's not in the drilling unit after that primary term is not being used for a well, those lands are released back to you, and you can either keep them out of a lease or release them. As I mentioned, you want to limit pooling to just the amount of land that they need for a drilling permit. Don't give them such a lot of land to pool. You can lease specific strata. You can only lease down to a certain depth. You can lease just like the Collingwood Formation, for example. And provide a means to settle disputes other than taking them to court. The standard lease requires you to take them to court. You can, in the negotiations, change that to mediation or arbitration, which will save you a lot of money if you disagree. Now let's take a little quiz. This is based on some of the questions I've had. By law, only 50% of the land needs a lease in order for a company to drill a well. That's false. Now, they may compulsory pool somebody, but they have to have all the land that well is going to harvest demonstrated to the supervisor of wells to make sure everybody gets paid for their minerals before they can get a drilling permit. By law, only the state of Michigan can receive a 1/6 royalty. False. You can negotiate any royalty you want. Okay, I'm going to go through this real quick because I'm running out of time, but another term that's always in the standard lease is a shut-in well. And like what I just talked about, the guy that's got 6 wells on his property and is not getting paid a royalty, that's technically a shut-in well. It's a well that's drilled, but they're not producing it. Well, the standard lease basically allows them to pay you $1 an acre for as long as they want to keep a well shut in. Landowners have learned they can limit that to 3 years, for example, and for every year it is shut in, they can increase that payment per acre. Okay, this is an example of some farmland in eastern Colorado, and this is where you can group the wells on a pad. There are 5 wells there, and there's 5 on the other end. This is what they're doing in the Marcellus Shale. They're grouping the wells so you don't have as much surface impact by having wells and roads and tanks scattered all over. Friendly to the surface owner. Brine disposal, central production facilities. These are always in the granting clause. You grant the disposal of water, brine, and other fluids. If that's in your granting clause, that means you are allowing an injection well to dispose of brine. If you're in the know, you know that putting things down the hole is not producing oil and gas, and if you don't allow that, and if you do allow a brine well, you can be paid extra for that. Central production facilities, in the granting clause, you say they can put in surface facilities. Well, that's not producing oil and gas. If you change that, and they want surface facilities, you can be paid a right-of-way or a lease for those types of things and get extra money. Anything that's said to be effective has got to be in writing. If it's not in writing, it's not going to happen. Water quality protection, very important. We have language that you can put in a lease to help you ensure your water quality is maintained by getting a third-party laboratory to do the water testing to get you a baseline water quality, testing during drilling and after drilling, and if that water quality is changed, require the oil and gas company to mitigate that change. I've seen leases in Michigan where the oil and gas companies have agreed to do those things. Non-development areas, here's the really important. This is right out of the state of Michigan regulations. Any person who enters into a lease as lessee, which is the oil and gas company, cannot deduct from lessor's royalty any post-production costs unless the lease provides for it. So they put it in the lease, and it's up to you to know you can reject that. And then it goes on to say these are some of the costs that can be deducted and others if in the lease. In fact, the standard lease says costs and fees of any kind can be deducted. Okay, this is the Pioneer Well in Missaukee County. This is the first well that was horizontally drilled and hydraulically fractured that was a horizontal well. And like people have said, it is a bigger scale, 4 acres usually for the pad. There's a semi-truck. So you're talking about bigger wells, bigger equipment than what Michigan has been seeing in the past. And there's only been about 12 of these wells drilled so far, but a lot of permits that are being sent to the state are asking for horizontal wells, so it could be coming more and more. In the negotiations, you can talk about surface damages. You can map out where you want wells and roads to go. You can do a lot of negotiating to minimize the impact on your surface before you sign that lease. The state of Michigan requires that in their lease. The standard lease just talks about payments to growing crops. Well, if you're a crop farmer, you could have tile, the roadways, tank batteries. Those you can get paid for all of that surface usage. You can require your roads to be all weather. You can fence the site, water quality testing. Make sure you can accommodate sprinkler irrigation. Put in the lease that they cannot put facilities that are going to interfere with sprinkler irrigation. I'm working with somebody right now that's part of a wind farm, and what they're trying to figure out is what is a fruit tree worth. They didn't have anything in the lease that talked about paying for damages for permanent crops, and you can't believe how many hours this guy has spent trying to convince the utility company what a fruit tree is worth. Okay, almost done here. This is a well site that's going to be used for hydraulic fracturing. You can see they got to have it level. And knowledgeable companies and knowledgeable landowners can take a look at this and immediately see something missing. It's called a pile of topsoil. You can require in the lease that they segregate the topsoil, put it in a pile. When they go to reclaim the land, put the topsoil back on top, and actually oil and gas companies in Colorado, once they learned how to use this, it ended up saving them a lot of restoration costs. Just mentioned, we have information on right-of-ways on the website. You guys are doing the right thing. You're doing your homework, getting information and asking questions, and hopefully that'll help you meet your goals and give you the maximum income from those wells if you get a well. And that's it.